One wrong flight after a layoff could end your H-1B journey instantly. Immigration attorneys are warning H-1B visa holders that traveling outside the United States after losing a job can be extremely risky, even if the visa stamp is still valid. If an H-1B worker is laid off while visiting India or any other country, they may not be allowed to re-enter the U.S. because lawful status is tied to active employment, not the visa stamp alone. The 60-day grace period applies only while the person is physically present in the United States. Once you leave the country after termination, that grace period effectively disappears. At the port of entry, U.S. Customs and Border Protection can deny re-entry if the traveler no longer has a valid employer or approved petition. Attorneys say border officers focus on current employment, not future intentions. Simply planning to job hunt after returning is not enough. Even carrying an old approval notice may not help. The only relatively safer option is if a new employer has already filed an H-1B transfer and ideally has received approval before the worker travels. In that case, the individual must carry the new approval notice when returning. Without this, attempting to re-enter the U.S. after a layoff can lead to denial at the airport and forced return. Experts strongly advise H-1B workers to avoid international travel if termination is possible or recent, and to consult an immigration attorney immediately. In today's enforcement climate, a single travel decision can permanently derail legal status and future U.S. work opportunities.